Değerli katılımcılar, girişimin için nasıl
Distinguished participants, welcome to the panel about how we can prepare for entrepreneurship. Today we have three guests. We are going to talk about the valuation and intellectual property and also the legal side of entrepreneurship. At the beginning of the panel, I'd like to introduce the esteemed panelists. Our first guest is Professor Dr. Ali Hepshan. He's a member of faculty at Istanbul University. Our second guest is Özlem Arslankourt. She is an expert in intellectual property rights. And our third guest is Okan Arıcan. He works at BTS. He is a partner and lawyer at BTS. Today, we are going to talk about the way in which we can prepare for entrepreneurship. And we are going to talk about the most critical three elements with very specialized and valuable guests. The first question I'd like to ask Professor Dr. Ali Hepshan. So valuation is a paradox for entrepreneurs because they don't know the way in which they can do the valuation, which means or which tool they can use. So it's a very relative issue whether the valuation is very high or very low. So when it comes to the startups, do you think it's possible to have a scientific valuation? Can you elucidate this topic for us? Thank you very much. Especially when we talk about the startup side, we are talking about the companies that don't have a history of a background, but which have a high potential of growth for future. And secondly, as in every company, access to finance is very important also for startups. Of course, we have conventional approaches when it comes to access to finance, especially IPO is one of them. Borrowing is one of them, but when it comes to the company structures that we are talking about companies that don't have a structuring coming from the past. So their access to finance in today's conditions can only be ensured via new generation financial tools such as crowdfunding, as you know, the angel investors and entrepreneurship capital, investment funds and partnership approaches are very important. But we all know that correct valuation, realistic valuation are a must for access to finance. It's actually a paradox because when you look at the partnership structures of entrepreneurial companies, naturally speaking, nobody would like to transfer a much higher share than what they already have to the other party. But we also see that no investors would like to invest in overly inflated companies in terms of their valuation. So valuation is of critical importance. So when we talk about the valuation processes of the companies that we talked about, and you refer to the analytical processes, we need to see and look at the international valuation standards. And we need to use the conventional approaches such as reduced cash inflows or markets multipliers. They will have an influence on the growth periods of the startups. So these are approaches that can be used in the maturity periods of the startups. But on the other hand, we have companies that don't have a past of more than 6 months, that have a lot of question marks for the future, that haven't been able to access finance. So when it comes to such startups, valuations are difficult, they are more relative, or they require more sensitivity or sentiments in terms of the approaches. So here, especially when we look at the approaches that are used in the early period and the approaches that are used in the growth or maturity period need to be distinguished from one another, because as I just mentioned, especially when we talk about companies that have a certain history that can create a cash flow and that have accessible financial data that are starting to have more or less a sustainable structure. So when it comes to such venture companies, we see that when it comes to reduced cash flows or market multipliers or relative valuation can be used as part of the conventional valuation approaches. But when we talk about early period, we talk about qualitative approaches where the sentiment is more in the forefront. So in the classical approaches, we use a deduction method, but here we use an induction method. You also know Berkus has a valuation approach for phases, and the scorecard approaches come to the front. So here we focus more on the technology that's used, the idea, the partnerships, the power of the market, and the potential of the market are more in the forefront when it comes to such evaluations. Therefore, we need to distinguish the structure into two. So we need to have a separate mentality for the growth or maturity period. But on the other hand, when we talk about the seed or the early periods, we need to have a different mentality and different approach. Thank you very much for your esteemed opinions, dear professor. What you said are very valuable because it's very beneficial, because when we talk about startups, we are thinking of a huge ecosystem, and we need to distinguish this ecosystem to several stages for valuation. When it comes to the scale up or the aftermath, the conventional valuation methods can be applied. However, in the pre-scale up process, when it comes to the seeding period, we can no longer apply the conventional valuation methods. I think it's been very important that you have underlined this. The second question I'd like to ask you, Mrs. Özlem Aslan Kartan. So when the entrepreneurs knock on the door of the investors, how should they preserve their ideas? I also receive entrepreneurs, they say, I have an idea, it's going to be $1 billion, but I cannot tell you because otherwise it's going to be stolen. So entrepreneurs also have such concerns and fears when it comes to their ideas being stolen. So first of all, thank you so much. Actually, the biggest fear of the entrepreneurs is indeed that their ideas and their projects are stolen and imitated. Therefore, entrepreneurs lose a lot of time in this process because we have a lot of discussions with the entrepreneurs about these topics. Generally speaking, what I suggest to the entrepreneurs is the following. A lot of technologies are produced in the world, and nobody hides their ideas for fear of them being stolen. So, of course, you shouldn't tell everyone your projects that will turn into entrepreneurship. Therefore, before you go to the investor, you can patent your inventions, or you can register your ideas, whatever you are going to propose. If you do this, you are going to feel more that you are in your comfort zone, and your project is going to be examined with more seriously by the investor. So this is also our topic. For that reason, all these projects need to be registered. Thank you so much. Then let's give the following message to our dear entrepreneurs. If you have an entrepreneurship that's patentable, that can be patented. So before you talk to the investor, please talk to a patent company and take the precautions to preserve your patent. And afterwards, you can talk to the investor. And I think that's going to be the most appropriate method. I'd like to ask the third question to Mr. Okan. In the investment processes, in which part of the process should the attorney be involved in the investment process? Is it before or after finding an investor? As part of BTS, you're a very experienced attorney. I'd like to benefit from your experience. Thank you so much. We always have the following recommendation. If we divide the investment into stages, it has 4 stages. First of all, the letter of intention, where the entrepreneurship and the investor express their interest to see that they're on the same page. This can be a simple email. It can also be a written document, a contract, but it can also be a mutual agreement saying that I'm going to invest in you that much, I'm going to buy so many shares, and these are the rights I'm going to have. And the second stage is due diligence. This is an examination process where the investor takes a picture of the entrepreneurship, and then the binding contracts, the final contracts are signed. And finally, we have the closure of the business where the shares are exported and it's open to investment. So when the investors come to us, they're generally at the investment contract level, but actually at the first stage, they should talk to a lawyer when it comes to letter of intention. Sometimes they don't have a budget for this, and they can actually do this as a mentorship. So the universities and foundations have several mentorship networks. They can receive such mentorship from them, or they can also receive mentorship service from an investor. So when in the letter of intention, they talk about something other than money, then the valuation, of course, the valuation part is not something that the attorneys can talk to. This is not our field. But apart from that, when you talk about any other topic, you should definitely talk to a lawyer. So I talked about these letter of intention stages, because at that stage, the document says this is not a binding document. It's not binding for any parties. apart from confidentiality, it's not going to be binding. It says sometimes the entrepreneurs might have the following policy. They say it's not binding, let's just sign it for now, and then we can change things in the process. So when it comes to the market trends, of course, we also see this in Turkey. Generally speaking, the letter of intention considerations shouldn't change afterwards. Once you understand that you're on the same page with the investors, the investor comes to the due diligence phase. They hire financial advisors, legal advisors. But if you say in the third stage, oh, this is what we agreed on in the letter of intention, but dear investor, I am no longer going to assign to you a seat on the board. You cannot say that, you shouldn't say that. So we often see this in practice when it comes to these letters of intention. How detailed should they be? How detailed shouldn't they be? What is the spirit of letter of intention? It's about the valuation, the amount of investment to be made, and the closing date. If not, the critical considerations about the shareholders' contract, should it also be in the letter of intention? So the draft letters of intention are not longer than 1 page, but most often in practice, I see that the letters of intention are almost as long as a contract for shareholders. Yes. So a letter of intention can be 2 pages or 8 pages. So of course, in practice, we see the shorter ones more often. And my opinion is also in favor of the fact that it should be short. But in addition to the valuation and investment amount, the letter of intention should also include the main considerations which will form the basis for the shareholding or partnership agreement. It shouldn't, of course, be a mini shareholding contract of 8 or 9 pages, but of course, it should detail the way in which the board is going to be composed or which rights the investor is going to require for the investment. So this will prevent loss of time for both sides. But after all, this is a strategy of the investor. If you provide a letter of intention at the beginning, then you will have it easier later on, because many times this is done on a negotiation basis. But what we see also abroad is that a couple of main concepts are written in 2 or 3 pages. Thank you so much for giving your answers, Mr. Okan. I would like to ask you more questions now that you are here, because our entrepreneurs also have a lot of questions. I would immediately like to talk about due diligence, because due diligence is a field in which entrepreneurs have a lot of questions. You have a lot of experience on that. Could you give us a bit more information on that? So due diligence, so this is appraisal or assessment in a way, that's how we term it. So when it comes to the valuation, the entrepreneur and the investor agree on the valuation and the rights. So the entrepreneur says, these are my customers, these are my invoices, this is how my company works. Of course, the investor believes that based on verbal declarations, and then the letter of intention is signed. But afterwards, the investor would like to really see whether the company is really what the entrepreneur told them, because they need to see how much shares they will have in the company. So they would like to take a picture of the current situation. Even though for entrepreneurs, this seems to be a process, for the investor, actually, this is also a checkup for the entrepreneur. So we do this as lawyers on the legal side. When it comes to the finance or tax side, we have financial advisors, accounting companies, accounting offices. When it comes to the technical subject, we have experts. For example, their certificates might need to be examined. So these are all assigned by the investor. It's actually a process that works based on declaration. We don't go and look into the drawers of the company during the due diligence and check their contracts. We just ask them to give us their detailed papers. So the investor would like to see the risks here. I always tell this to the investors. I say, this is actually something like a checkup. As an investor embarks on this process, they might not have guaranteed everything when it comes to the legal side. They might not have worked with a lawyer, or they might have overlooked many important considerations in that fast growth period. So actually, when it comes to tax and finance, this is the same thing also occurs. So there can be some shortcomings that are identified, and then the actions are taken in the forthcoming period. So I would like to ask Adi, so when you look at the conventional appraisal or valuation methods, which valuation approaches can be used for entrepreneurs? Could you give a bit more details on that? Well, actually, we just told about it because especially the company, the fact that the company starts to create cash flow, especially the free cash flow, need to be sustainable. That's very important. If the company has been having consistent and accurate financials in the past period, that if they also started to write a story for the future, then this shows us that the company is progressing towards a maturity and growth period. This being the case, we can use more conventional and more commonplace methods. So especially reduced cash flows is one of them. So the essence of the reduced cash flows is the free cash flows that the company is expected to create in the future based on a certain discount level. We get this figure. So the amount of which the free cash flow is created is important. So this is provided for the equity holders and for the company shareholders, and their future growth potential is also very important, because when it comes to the essence of the reduced cash flows, we see the expected future cash flows. They need to be appraised, so we need to assess the risk, and the reduction rates needs to be applied. So if the company is in the growth period, then we need to use the market multipliers, because when we call the reduced cash flows as internal valuation, the market multipliers actually enable us to compare the company with their counterparts. So when it comes to the national or global levels, the fiscal and financial multipliers of the company to be associated with the company's financial data. So this is how we try to reach a conclusion, but this is applicable for further stages. So we are talking about companies that offer a positive cash flow, that reach the social maturity, that have brand awareness, that have assumed a certain market share. So these methods can be used for such companies. Thank you so much. Özlem, as the founder of Esteemed Patent, you are very experienced in that. So how does the patenting process unfold for an entrepreneur? I'm sure our entrepreneurs are curious about it. Of course, they have an idea, they have a product. What do they go through in this process? Can you elucidate this for us? Yes, first of all, the idea or the patent that they have needs to be written in full details, because when it comes to additions later on, somebody else might actually be involved. They might develop the business further and get the patent. So they need to explain the project in full detail, as if giving a recipe. So we also talk about this with our engineers in the company. We turn it into a descriptive in this descriptive paper or an instruction book. So the patents are protected as of the date of application in Turkey and abroad. So in the first stage, they need to provide all the details. They need to include all the envisageable, predictable situations in their files, and they need to submit it to us. Then we can follow up on those. Actually, these files are then submitted to investigation, because there can be similar products in Turkey or abroad. So when we find an idea, it would be much more useful to have a preliminary investigation. For example, in a place where you least expect it, in Russia or China, you might have a similar patent or similar idea. Therefore, such a preliminary investigation could be life-saving. Of course, the entrepreneurs can then develop their ideas further and submit it to the investors. So when it comes to the patents, yes, we talked about the processes of the patent process, the steps of the patent process. I would also like to talk about the shareholding contract or the partnership contract. So, Okan, how does the process unfold when it comes to the partnership agreement? Özlem has given us enough information about the patent process. Could you also tell us more about this partnership contractual process? Yes, before that, I would also like to add the following to what Özlem has said. This is something that we see very often. So the entrepreneurs are afraid that their ideas will be stolen. When they come to us, they always say that what should we do with our intellectual property rights? We don't have intellectual property rights, they might say, especially when it comes to software. So when it's something that's not patentable, those who work on software. Of course, software can also be patented maybe, but I don't know how reasonable that's going to be. That's controversial. So often we see brand, domain, or website. These are always on the entrepreneur side. They always need to transfer it to the company, or they receive software development or support services from abroad. They say we have somebody that we know, we ask them to write these codes, but they don't sign anything. You also need to get the rights for the development you had externally done. You need to have a contract for the transfer of rights. So in the due diligence phase, we uncover all these things. And then for 2 or 3 years, they try to find the related persons for the development activity that they received from outside. They are trying to track the people who did this development work. So all these are within the ownership of the company. So they need to pay attention to this. So it comes to the shareholding contract. As I just mentioned in the letter of intention, apart from money, we also agree on other topics. So the angel investor or the venture capital fund or the acceleration fund, so whatever, the investor would like to share their, would like to protect their minority share because they don't have a control in the company in terms of management, in terms of partnership in the board of directors. Therefore, the investor would like to have some minority rights. Apart from what's written in the law, these are commercially agreed minority rights. So what is the board composition going to be? Will the investor be represented there? So when decisions are made in the board meetings on which topics will the investor have a right to say, generally it's not the investor that drives the process, but they have a right to say no. We call it the veto right. So they cannot push the gas pedal, but they can pull the brakes. So how is the system going to work? Can they transfer their shares? If they can, who will they transfer their shares to, etc.? So we're talking about such regulations. So the final aim is that the investor protects their own minority shares. But also this is a partnership agreement that the owners, the founders have within themselves. So we have two different, we always used to think of them as two different groups of beneficiaries as the investors and entrepreneurs, but the investors might also have divergences. They might have less belief in the company. For example, we've had pandemic, or they might have health problems, or one of the investors might go abroad, might move abroad. So the entrepreneurs and investors should also think of the situation. So how is it going to happen if one of our partners leave the entrepreneurship? So the partners, it actually defines all the management considerations of the partners in relation to one another. So we just resign this in each tour of investment. So this is a question that we have. Of course, the investor proposes this based on their own dynamics. And in the next investment tour, in the next investment round, if it's a brand new round, if they're talking about the Series A or Series B investment, each new investor might require new rights. So it can be added to the previous contract or a brand new contract can be signed. So I've always been saying that it should, again, be the entrepreneur who leads this, the entrepreneur and their legal advisor. Mostly we see in Turkey, the investors have legal advisors, but actually this is a fundraising phase. Therefore, the entrepreneur also needs to be in the driving seat, and this is what they should manage. So this is what we see more often abroad. So the entrepreneurs work with a good legal company. It's a difficult process. Let's say that you have 10 angel investors, 2 venture capitalists, there is an accelerator. So an entrepreneurship and a legal advisor need to coordinate this in this whole process. So should you go to the investment fund after you agreed with the angel investor? Who has how much share in the negotiation, etc., you need to agree on this because it's important or it's difficult to convince the investors, and you also need to preserve the relationship. Therefore, you need to focus on the details. So, as you mentioned, this year we've had 20 investments. When we look at these investments, we see that there are some issues that cause problems for us in the shareholding contract. So there are two issues. One is that for at least 3 years, the entrepreneurs need to be dedicated to that specific project. And sometimes the entrepreneurs might reject it, but I think it's very normal that the investors want this because they want focus. They are entrusting them with their money. What are your ideas about this and how do you interpret this contradiction? And secondly, on the other side, when it comes to the prohibition of competition among the investors, they also have an article according to which investors cannot invest in others. Entrepreneurs, but the investors might say, I only invest 1%. Why am I prevented from investing in other ventures? So, as Okan Arijan, what's your opinion on this? Yes, of course, the investor invests in an idea, in a product, but they actually invest in an entrepreneur. There are a lot of good ideas. There are a lot of successful ventures. We can also copy an idea. We can also start a startup. So the important thing is the way in which you execute it. So you actually invest in the entrepreneur. So I think it's very normal for the investor to require full dedication from the entrepreneur. Of course, it can also be that the entrepreneur can be a scholar at a university or they might have another job. They need to disclose it at first. They should say, this is also what I'm doing. I also have my family business or I teach for one day at university. So there can be exceptions, but the investor would not like an entrepreneur to set up 5 different businesses, especially in the early stage, because it's important for that idea to grow, for that company to flourish, to be on the market. So the entrepreneur needs to be actually involved. So it's important or it's normal that such provisions are included, especially in the first phase. But as I said, there can be exceptions. But what's important is that the entrepreneur needs to be careful about this. What if I don't do this? There also needs to be a sanction for this. And this is something that investors should take into account. So when there are 4 entrepreneurs, this is also a protection amongst the investors. So let's say we are 4 investors and as 4 entrepreneurs, and as one of the entrepreneurs, I spend day and night working on this, but the other entrepreneurs pursue other activities. So this is also an unfair situation. So you also need to look at the shares. So what's going to happen if one of the investors leave or if one of the entrepreneurs leave? So we have in Turkey this reverse investor. We need to have these accrual charts. So here, based on the messages that you have given to the entrepreneurs. So first of all, when you go to an investor, you need to definitely look at whether intellectual property rights belong to the person or to the company. If they belong to the person, they definitely need to be transferred to the company. This is the first message. And the second message is that, so serial entrepreneurship, generating several projects. I also see that sometimes they give me 8 or 10 projects. They say they are serial entrepreneurs, but investors would like the entrepreneurs to be dedicated. And therefore, you are receiving money that the investor has entrusted to you. Therefore, the entrepreneurs should know that they need to focus on their entrepreneurship. So I'd like to ask again to Mr. Ali. So when it comes to the valuation of startups, which parameters are looked at? Could you give overall information to our entrepreneurs? So based on what you and Okan told, I think we should also add the following. So first of all, for access to finance, valuation is critical, but also over time, based on or depending on the problems within the company, let's say one of the partners would like to leave, then of course it depends on whether the company is in the early periods or in the maturity or growth periods. We also need to determine the shares or the composition of the shares. So the valuation doesn't depend only on the financing at the beginning, but Also, when it comes to the resolution of the problems later on, valuation is of great importance. So when it comes to startup structure, if there is a bigger potential for the future, you need to identify the share values at the beginning. And when in the company is in the maturity period, there are a lot of differences in terms of the share values. So for that reason, valuation is very important. So we need to have a very detailed, a very well thought business plan. So in the valuation process of the startups, we have the scorecards, and also we need to have these staged valuation processes. So it's important to have a good business plan, and that directly has an influence on the investment. So it's important to have a very sound founding team or a good team that's going to implement the business plan. Of course, my opinion is the following. I mean, we can also talk about this later on, but it's not only about the main founders of the startup who bring up the ideas, but we also have mentors that support these founders. So which mentors they work with, which consultants they work with, or which scholars they work with, these are also important, especially when it comes to the financing side. Sometimes entrepreneurs may be lacking. So I think it's also important to see the way in which they receive external support. And I think that's another element of the team. So we are not only talking about the people who have brought about this idea. Of course, they are important, but if we are talking about a team, we also need to assess the side actors within this process. Therefore, we need to have a good business plan, and we need to have a sound team that implements this business plan. And thirdly, we have technology or prototype. So after all, especially in the early stage or in the seeding processes, these are one of the considerations that come to the forefront, because when it comes to the future of the company, if you don't have an idea about free cash flows, if you don't have enough information about the financials of the company, so we can focus, or we can shift more to sentiment-based approaches. Therefore, it's important to have a sound team and to see that the technology that's used. So especially when it comes to this evaluation processes where sentiment is more important, we need to have the strategic partnerships, especially partnerships with techno cities or with chambers or with international organizations. So there are such partnerships with international organizations, and these suddenly have an impact on the value of the organization. Also, in the consequent process, the stable growth or the promising profitability structure of the company also have an impact on the valuation process. Now, I'd like to ask you the following question. When it comes to competition, what are the advantages of a patent? Can you inform our entrepreneurs? Yes, actually, when there is a patented product, you have eliminated competition. There are no competitors, because you are the sole holder of your project and your investment. That makes you unique. Of course, in these processes, also after you get the registration of the patent, it can be that you are imitated or your idea is imitated. So you should definitely talk to a lawyer, and you need to intervene on imitated goods. We have this very often in Turkey because the culture of brand and patents has been flourishing only recently. For example, abroad, we have also friends who are trying to get the name of Steve Jobs. They are textile entrepreneurs. We are also trying to explain this. Or there are very famous brands, and they are trying to use their names, but those brands are also very specially protected. So people also need to investigate this part, and they actually cause problems. These problems are self-inflicted on them in the long term. So let's go back to the partnership agreements when it comes to partnership contracts. So when will the standard documentation in partnership contracts become more widespread? So let's say that the company is set up in Delaware in the US or in Estonia. After you sign these partnership contracts, Can you give us more information about this internationalization of the partnership contract? So yes, when it comes to these partnership contracts, you need to work with a lawyer who knows the law of the company, or if it was written by somebody else, it needs to be revised. Of course, the partnership contract of a Turkish company can also be subjected to another law. It can, for example, it can be subjected to British law. So when it comes to the executability of the clauses, you might need to adapt it to the Turkish law or to the local law. Abroad, especially in the US and the UK, and when it comes to this documentation, there is a very standardized process. There's MBCA in the US, National Venture Capital Association, and in the UK you have EVCA. So when you look at their website, you see seed stage, Series A or Series B, so you can see which documents you need to sign at which phase, and you can get their drafts. And this is something that's also very well established among the entrepreneurs. So when you go to the US, you know more or less what rights you are going to have in the seed stage. So so you have given a tip to our entrepreneurs. If you set up your company in the US, you can have access to such draft texts that Okan mentioned. So yes, exactly. When you also go to a lawyer, they say we are going to use these documents for the seed stage. They can trim them, they can retouch them, but they don't prepare a brand new contract. So when you send this to the counterparty, to the investor also recognizes this. So it's more about commercial considerations that they talk about. It's more about, or you talk about more extraordinary situations. But unfortunately, in Turkey, that's not the case. So in the last 6 or 7 years of my 11 years career, I have been serving only in this field. So at least in Turkey, certain rights are at least well established. They are not written, but at least I can say that there is a common practice in the market. But of course, it needs to be written, and this changes among law offices. Perhaps the lawyers need to come together, and we need to coordinate this. We also need to talk with investors, such as valuable angel investors. So this can be done under the umbrella of an NGO. For example, in the US and the UK, you have this draft, and I think it can also be done in Turkey. And I think it should be, because it makes us lose a lot of time, because for example, you can receive a certain contract from me, but another law office can provide you with a different contract. They actually say the same things in essence, and the investors have more or less the same expectations when it comes to their rights, but the way in which the contract is worded is very different. And the entrepreneurs and investors also spend time on this. They also pay money to their lawyers. They receive the service. So I think standardization is going to be in everyone's favor. So based on my experience, when it comes to the investors, we have the following concerns. I can say you this. This is also an important message for the entrepreneurs. If an entrepreneurship has multiple legal personalities, let's say in Turkey and in the US, then the investor says, okay, I'm going to invest in the company in Turkey, but I'm going to have shares in the company in Turkey. But if you don't give me shares of the company in the US, then the property rights can be transferred to the company in the US, and the company in the US can exit, then I will be devoid of the benefits. So how should the entrepreneurship take an action? So what are the concerns of the investors? Or yes, the investors are right in having concerns about this. As I said, when you make an investment, all the intellectual property rights, domains, patents, whatever is there, needs to belong to the company. The employees and the entrepreneurs also need to be part of the company. But when you establish a company in a different country in the US, even if it's just for the sales office, the investor doesn't have any stake in that. And as you said, the IP can be transferred abroad. That company can have a different partnership structure, but the investor needs to have benefits on the entire elements of this investment. Therefore, all of these companies need to have organic connections. One will be the umbrella organization, the other ones will be the sister organizations or dependent or child organizations. So mostly Entrepreneurs asks whether they should set up the company in Europe or in the US. These depend on commercial considerations, where you're going to sell, for example. It also depends on tax-related issues, how much are you going to pay, how will you bring your money to Turkey, what do you pay if you exit here. So you need to work with legal and tax consultants in order to structure the organization. So we say the following: before you come to the investor, if you have legal personalities in multiple countries, then you need to have this communication in such a way as not to hurt the investor. If there is an organic connection between these legal personalities, then the investors will not be harmed. So our message to the investors is that if you have legal persons in different countries, because you should know that the investors will be concerned because these are separate entities. So I'd like to ask you the following, Ali. Sometimes I receive entrepreneurs, they say we will go to this great organization, we are going to have the valuation of our startup, we are going to give so much money in order to disclose our actual value. Do you think this is important? Or do you think this is possible when it comes to a startup entrepreneur? Can they go to a scientific organization and can they have a realistic valuation? Well, actually, it's a relative. Valuation is relative. It is different based on the perception of the person who holds the idea or the entrepreneur or the investor. So the aim, along with the report that's drafted, is to have reconciliation between both sides. This is a paradox. On the one hand side, the entrepreneur is concerned if they are giving too much, or the investor might be worried that the entrepreneurship is inflated in value. Of course, you need to eliminate these concerns. So I think such reports can be received from all of the specialized organizations in that field, especially in the early periods. I think it might be too early to go to these well-recognized institutions to get the valuation, but if the company has been mature, if they're getting ready for an IPO, we also see examples of these globally speaking. Also, we see this locally. So I think it's possible to go to such a recognized organization at a future stage. So, but when it comes to the maturity or growth phase, you actually can do the valuations based on international appraisal standards, and the financial advisors prepare the reports as such. But on the other hand, when it comes to the early period, sentiments are more in the forefront. So I also brought to you the numbers in the latest valuation efforts we had. We had the scale. So you can have different conclusions based on your valuation. So for example, the team has a weight of 30%. And we also talked about the auxiliary elements. The growth potential of the market has a weight of 25%. Product and technology have a weight of 15%, competition 10%, marketing and partnership 10%, and the additional investment need has 5% weight in the valuation. And 5% is the other. So we need to look at the closest global competitors of the investor, and we added this to the median values. So this is just a sentiment. You can weigh them differently. You can have different weights. You can have a different outlook on the team, or the competition environments or the market can be assessed differently. Therefore, we are talking about a relative approach. It's not possible to say this is absolutely the value. And I think it's much more difficult for such structures because we don't have their financials. We have their future potential, but we don't have any story from the past. Therefore, it's a bit difficult to have a guess for the future. So valuation is not our field, but when it comes to the shareholding contract, the investor base themselves on a certain valuation. They buy a share. They say that they pay 10 liras for the share. So they say today I pay 10 liras for one of these shares. If in future there is a new financing tour, if you export it at a higher value, then my rate of shares will be diluted or eroded. It's actually in the nature of this thing. And because the capital shares of the current partners have a certain chance, but let's say when I paid 10 liras for this, but if a new investor pays 8 lira, then I will have made a loss because you made this company more valuable. You should have exported them at a higher value. So they might say you should protect me. So a new investor gets value based on 8 liras, but the previous investor gains value based on 1 lira. So you also set your own target in the next round of financing. If you have a very high valuation, but if you are not going to reach the same valuations in the next financing rounds, then you need to preserve the existing investors. And in the end, the entrepreneur has actually a lower share of the capital. So the entrepreneurs might actually harm themselves when the valuations are too high, because in the market, there is a trend or there is a perception that it's important to have high valuations, but actually it might be counterproductive. Yes, that's very true. Well, when we look at the practice and theory, they might be differing from one another. So when you look at the structures of their startups, when you look at the financing size that's needed, we assign it in parallel. And based on the need, we try to find different channels in order to direct the funds. But actually, you need to have it in a top-down approach. You need to look at the future potential of the company. You need to look at the team, the business plan, the process management, and the partnerships. So actually, you first need to identify the value of the stake. And based on that, you can see where you can find the required finance. Yes, I think this has been a very fruitful discussion for our entrepreneurs. There are many reasons. As Ali said, after the scale-up phase, the professional financing companies become very rational. But before the scale-up phase, the professional financing companies might not have as much influence as they would have in the aftermath. So we need to underline the following. Before the scale-up phase, when it comes to the seed, the startup phase, as Ali said, this valuation is relative. So you declare a certain value and you have a certain negotiation based on this value. So our entrepreneurs need to know that this valuation is subjected to negotiation and it's based on an estimation. It's a very important highlight. So Okan has also underlined the following. As the entrepreneurs, they would of course like to have the valuation at as much as high as possible. But as Okan said, when it comes to the non-dilution clause, if in the next investment round, if the valuation is lower than the previous round, then the partners might give this from their own shares. So even though entrepreneurs would like to have the valuation to be as high as possible, this can be counterproductive in the long term. So Ali has also mentioned it as follows. If an entrepreneur an entrepreneur definitely needs to think of the future financing rounds when they are collecting funds, investment funds. And I think this has been a very valuable discussion for our entrepreneurs. I like to talk to Özlem. So those who have reached success in the entrepreneurship ecosystem, what do you think they've done differently than the other entrepreneurs? So actually, I can say the following. I think that the entrepreneurs need to have very nerves of steel. I think this has been spoken a lot recently, the psychology of entrepreneurship, because really the ideas about their projects are very important. Their team is also very valuable, so they need to go with very sound steps. So also trial by error method needs to be used to keep their psychological integrity. And I think that they should be more perseverant, because sometimes when the entrepreneurs come to us, they come to us with several partners. Let's say one of the partners can leave in the process, and the patent belongs to the three partners. If one of the partners leave, there is actually a pending question. It's not known who the patent belongs to. Therefore, as Okan Bey said, it's important to have this established at the beginning. For example, they see the patenting processes as cost, but actually these are minimum amounts because otherwise in the long run, they might pay even higher costs. Therefore, when it comes to the legal side, they need to consult a legal expert. When it comes to the patents, they can consult specialists and this will be in their favor in the long run. So actually, Ali and Okan can receive this question. I'm addressing this question to them both. So when an entrepreneur is searching for an investment, so in English we call this a run for investments. So they identify at the beginning how much investment they're going to need. But the shareholding contract is also subjected to a bureaucratic process. There needs to be an extraordinary general assembly afterwards. It needs to be registered. So I'd like to ask the following to Okan. So when our entrepreneurs are in search of investment, how much leeway, how much of a time period should be included in their whole phase for these bureaucratic or legal processes? Sometimes inexperienced entrepreneurs think it's just going to take a few days and it's going to be signed, etc. Then they will have the money. But actually, it's a very bureaucratic process. You need to fulfill certain obligations. How much time do you need for this bureaucratic phase when it comes to financing? Yes, the entrepreneurs come to the investors, they present their ideas, the investors assess them, they make a decision, they say, okay, this is a good entrepreneurship, we can invest in it. Then we talk about the letter of intention, the acceptance of the letter of intention, the due diligence, and the investment contract. It's a long process. As I mentioned, there are 4 phases of this process. From the first phase to the 4th phase, generally speaking, for the very early period, this is about 1 month. So even if you, let's say you don't have a company that requires due diligence, if you don't have enough documents or formalities within the company, it shouldn't exceed 1 month, but in practice, it can be longer. If you ask about it, yes. When it comes to very small investments or if there are very crowded capital charts, of course, it might take longer. Of course, the entrepreneurship should also be on top of this process. They can say, they cannot say, I'm just going to transfer this task to my lawyer. I don't want to deal with this. But this is not possible because this is a partnership process in which they are directly involved. And I think the entrepreneur should always work with their lawyer. They need to be engaged in this process and manage this whole process. Let's say you have 10 angel investors. Let's say you have 3 contributions from the funds. You need to coordinate all of this. It's the whole process and you need to design it well. So when it comes to the future stages, let's say you have a well-established product, you have enough sales, you have customers, you have suppliers. So for such companies, I think it should take about 2 months or 2.5 months. If it's longer than 3 months, we believe this is too long. Of course, I'm talking about the early process. When it comes to larger or more mature companies, this can be up to 4 or 6 months. You need to work with sound advisors for financing and legal side. You need to work with people who know and plan the process. It's not only a simple process where you send the contract to the lawyer and then they send you back. So sometimes you have this closure procedures. After the General Assembly, you need to set up the dates in advance. You need to coordinate it very well. Otherwise, it can range up to 8 or 9 months. So for some investments, we have limited companies, dear entrepreneurs, because the investments are on joint stock companies. So they had to convert it from limited company to joint stock company. How long does that take? Yes, I also mentioned this in all the trainings. Yes, you can start with a limited company, then you can convert it to a joint stock company, to a corporation. So, for example, you can have premium shares. So an investor does not invest 1 million liras, but they can export the capital as a nominal value. So taxation is not my field, but we always encounter this. So we have this specific regulation for joint stock company when it comes to the export of the capital. So if you have if you have had your shares for 2 years as a joint stock company, you don't pay taxes if the stock value has increased. So conversion of a limited company to a joint stock company, it requires a lot of formality, a lot of red tape. You can do this with a lawyer, or you can also work with a financial advisor. Large offices also work with commercial registries. This can be completed in 1 month or 1 month and a half. So if you are talking to the investor, you should do your preparation well. You should already make a headway, but you need to increase your capital if you go from limited to joint stock.
Bu bir finansman I would like to add that it's actually the access to the financial resources takes time, and of course, this growth or the maturation is different, but all the processes are different. So the entrepreneurs, if their access to the financial resources will take will take some time. They need also a working capital. They have to plan it so that they can continue their financial transactions, or to have the skills at least, because maybe you produce a product, but producing it doesn't mean that you will always have the cash. So managing the cash, especially, of course, it's also important after the process, but it's also important to manage the cash in in a good planned way, so that how they can be more prepared for this process. So I would like to extend my thanks to the participants for their attendance. And so I would like to make a small summary. Professor Ali said how they played a different role in the scale-up steps and before the startup and maturation period, of course, or most of our entrepreneurs are in the startups, and it's a conceptual differentiation actually, and it doesn't rely on a scientific evidence. And Mr. Okan also talked about the contracts, about how the shareholders abroad can have some standard drafts, but we still don't have it in Turkey yet. And of course, in addition to that, the entrepreneurs about the share contract, they can have a look about a 3 months perspective, or it can go up to 6 months. But for our entrepreneurs, again, for financial planning, the entrepreneurs shall do it according to these motivations and considerations. And before going to the investors, you need to talk with a patent company so that you can have a clear vision about that. And in addition to that, Mr. Okan also told that if the brand and patent belongs to you, if it's okay, but if it belongs to a person, you have to transfer it to the company before going to the investor. So both for the intellectual properties, both for the finance, we have seen the old links about all these issues. And I would like to extend my thanks to every speaker here. I hope it was a furious